Hey everyone, and welcome to a quick video looking at two motions filed in the Karen Read case yesterday. The first one we will be looking at is one that kind of made a big fuss on the twit because it is the Commonwealth's motion to refrain the defense from mentioning that the injuries on John O'Keefe's arm was caused by any person or animal that was inside the home of 34 Fairview. Some people said, well, they could just say, well, the defense isn't allowed to put on a defense. Read it again and go back and see Beveridge's ruling that they are not allowed to mention people in the third party culprit defense in the opening statements. It's the same as in the last trial. What they are allowed to do is to show the now infamous picture of John O'Keefe's arm with the abrasions and say, this, ladies and gentlemen, is what the state claims happened to John O'Keefe's arm when he was struck by a vehicle. Any one of you can look at this picture and make up your own mind, but this doesn't make sense. We will provide you the facts during this case, so when we return in the closing arguments, you will agree with us. Those marks were not left by a Lexus traveling at 24.3 miles in reverse. This is one of many, many, many examples of reasonable doubt that you will meet in this case that will prove Karen Read is beyond any reasonable doubt innocent. There is no explanation that the state will give you during this trial that can explain these marks to the arm. Use your own mind, use your own eyes, and make up your mind. But we will allege this has nothing to do with being struck by a car traveling 24.3 miles per hour. They can mention the injuries. They can just not say these are cut marks made by Coco when she was slicing up lemons for the drinks, or they can't say these are bite marks from Chloe. You don't need it in the opening statements. A lot of people are saying, well, they should say everything in opening statements. It's going to be 6 weeks from the opening of the case till the defense even gets a bite at the apple. We've seen in other cases, I don't know if you can do this in Massachusetts, other cases you can defer your opening statements till before the defense part of the case starts. With so much crap we know is going to be spewed by Brennan, I might even say, no, we're not going to do opening statements on the first day. We're going to do it when the state rests, because it's going to be so much crap that you can then do in the opening statements. But you will maybe say, well, then they don't know where we will be going. But again, I'm not a lawyer. I'm just a talking head on the YouTubes. The other motion that was filed was the text reenactments that Brennan wanted to do. And I, for one, had envisioned a high school production where Plevin could be reading John O'Keefe, KP could be reading Karen Read. Remember, totally unbiased people reading it. But the defense won't go along with it, and I don't think they should. First of all, as they noticed, it's filed way too late. Remember when Brennan was crying about all the late discovery? Now he's filing this late. And the Commonwealth's request was limited to a single wake sentence without any supporting legal authority, and was not made until long after this court's deadline for filing motions in limine. Attorney Brennan again discussed the idea of using independent readers during April 16 motion hearing, more specifically detailing the Commonwealth's desire to use independent readers to present various electronic communications between Ms. Read and O'Keefe. The defense quickly objected to this inappropriate theater, especially given the high probability that such a state's delivery could be unduly prejudicial against Ms. Read. Footnote: Although Brennan states that there would be no inflection that would be inappropriate, the defense does feel it is prudent to take that risk. If a jury were to hear these messages read inaccurately, no sustained objection or striking from the record would successfully undo this damage. This is exactly why he wanted read, because you can then infer that there's a different meaning behind the text than there was in reality. Notably, at no point in its writing or oral arguments have the Commonwealth provided any legal authority or basis for its desired use of independent readers in this context, namely for the reading of text messages. And then they'll go on to state, in every other case and in the first Karen Read case, this was done by an officer. This was done by Trooper Guarino, who read the text messages as we see it in every other case. They have done the homework that the state didn't do, because Brennan never, ever, ever cites case law. They have looked through everything and they haven't found one single piece of case law that supports what he wants to do, which in of itself should make it not admissible. They also say that the independent readers is an inappropriate way to convey electronic communications. And I totally agree. Imagine you are having me with my deadpan delivery, sarcastic way of reading, or you are having a very highly emotional reading. If we just, let's do an example. And they lived happily ever after. And they lived happily ever after. Totally same sentence, but it emotes two very different things. This is why they should not be allowed to put actors on the stand to perform text messages. Text messages are written communications. Written communications is not the same as verbal communications. That's why the jury should just read it, or a trooper should read it to them, and then they can read it back in the deliberation room. Exactly what the defense is saying. We have no case law supporting what's going on. Another thing, Brennan said he wants to use it throughout the case, and that's also one of the things that the defense hammers on. Lastly, at the hearing on April 16, Brennan asserted that it is not sufficient to simply have a state police officer who is not a witness to those text messages come in and read them continuously throughout the trial. As described in detail throughout this motion, we firmly disagree that it's not sufficient to have an authenticated state officer present text communication in a trial. Beyond that, though, and Attorney Brennan suggested that these messages comes in continuously throughout the trial and at different parts of the trial when they become relevant, does not appear to be practical or procedurally sound. Subnote 4. Additionally, where text messages has been admitted into evidence, there is no need or purpose for their repeated reading to the jury, as they will have ample time to review these communications along with other evidence during deliberations, and counsel may reference them by citing the record. Given the Commonwealth's failure to provide any legal foundation for utilizing independent readers, it is difficult to know how they intend to introduce text messages continuously and when they become relevant. Regarding Trooper Guarino specifically, during April 16, Attorney Brennan suggested that bringing Trooper Guarino back repeatedly would create the wrong impression. Given that Trooper Guarino was able to introduce the exact same messages with ease during his continuous days of testimony in the first trial, we remain confused by the Commonwealth's concerns. Regardless of procedural underpinnings, Ms. Read opposes this idea of continuous introduction of messages in general, as it sounds bulky, inefficient, and unduly prejudicial. For these reasons set forth, we request that it's stricken. I don't believe that Bev should allow it. Do I think she might? I'm not sure because it's Bev. But every time they want to refer these text messages, they should just say, well, as you know, Trooper Carino came in and read these text messages. You can go back and check them. They can bring it up on the screen. They don't need to have the local community theater come in and do a dancing interpretation of text messages every time they want to mention them. But what does this tell us? This is filed 4 days before we're going to start the second trial, a trial that has been ongoing for 3 years. They already had the first trial in this case. And to me, I see this as Brennan grasping at straws. He has no facts. The first trial, Chloe is bunk. There's no reason to even talk about the dog. Now, we want a guy to come in and confirm it could be dog bites, but it could not be Chloe. So now you're entertaining that a dog could have attacked John O'Keefe or get to the corpse after. Why did you change your mind? You want people to come in and do an interpretation of text messages. In the first trial, Lally claimed these text messages were so damning that would be the thing that nailed her, because that proved she had ill intent when she hit John O'Keefe that night. Now you need someone to come in and play it for the jury to see that, she clearly meant this as a precursor to hitting him or after hitting him, which is kind of ridiculous. Why would she still keep hating on him after she hit him if she already knew he didn't want to come back? That's not how you make an alibi. This, to me, seems like Brennan is grasping at straws. His case is horrible. He signed on for an easy paycheck. Now he found out on the eve of the trial, he has nada. SIP sells nothing. You can go to all the aunties and they can tell you, all the vehicle data is going to kill her this time. Why haven't we seen one single motion about the vehicle data? He wants to keep Arca out. He wants to get Chloe's teeth marks in. And now he wants actors to try and emotional blackmail the jury into believing the text says something that he can't make them say if it's just written off a screen. This case is going to be dirty. Brennan is desperate. They should have done what I said. When they fired Trooper Paul, they should have washed their hands, walked away. But ego, or whatever the problem is, got the better of them. I can't wait till next week. This is going to be horrible for the state.